associated with presenting and defending that scholarship in a professional conference-style setting. Today's presentation will be made by third-year student Elyssa Lacson. Before I introduce Elyssa, I'll introduce the respondent to our presentation, Professor Michael Noon. As you know, Professor Noon served 20 years as a judge advocate in the United States Air Force, retiring as a colonel before he joined the law faculty in 1978. He's a fellow of the Inter-University Seminar on Armed Forces and Society, director of the International Society for Military Law and the Law of War, president of the Committee on Military Criminology and Crime, serves as a member of the International Advisory Board, Geneva Center for Democratic Control of Armed Forces, and on the executive board of the Judge Advocates Association in a court. He was a distinguished visiting professor of law at the U.S. Military Academy in 1991 and co-authored the textbook used by the law department there. We thank him very much for coming to help us out today. Now let me introduce our presenter, Elyssa Lacson. Elyssa received her B.S. degree in Foreign Service from Georgetown University in May of 2008, where she majored in International Politics and Security Studies. Prior to law school, she worked as a paralegal at the New York County District Attorney's Office in the Appeals Bureau and as a paralegal in the Financial Restructuring and Antitrust Departments in the D.C. office of Cadwalader, Wickersham, and Taft. Currently, she's a lead article editor of Volume 62 of the Catholic University Law Review, who nominated her work for this year's series, and she is a teaching assistant for Professor Beverly Jennison. After graduating and taking the bar exam, she will begin in the fall as an antitrust attorney in the Mergers I Division of the U.S. Federal Trade Commission. Elyssa's interest in her topic was piqued by her externship at the U.S. Department of Justice Office of International Affairs, Litigation, and Legal Policy Group. She gained valuable experience by working closely with DOJ's attorneys in preparing for state-level litigation, researching legal issues arising from complex international extradition cases, and writing memoranda used in the negotiation of bilateral law enforcement treaties. She spotted a synopsis of Trinidad E. Garcia versus Benov case in the U.S. Law Week and realized that the case's challenges to State Department practices were unique and worth writing about. So I'll now turn the floor over to the second of this year's student scholars, Elyssa Lacson. The title of her presentation, Subjected to Torture, Chevron, and the Limitations of Judicial Review of Final Executive Orders for International Extradition. Elyssa.
Hi, welcome everybody. And I would first like to thank Professor Harmon for putting on this great event, Professor Noon for being my respondent today, and the Law Review, of course, for submitting my paper for consideration in the Student Scholar Series, as well as all of you guys for attending and supporting me in this endeavor. First, so my paper, Subjected to Torture, Chevron, and the Limitations on Judicial Review of Final Executive Orders for International Extradition. It's a bit of a mouthful, but I needed all of that in there. I wanted to first show you this map because right now this displays all the countries in the world with which the U.S. has bilateral extradition treaties. It's my time working at OIA, which kind of really opened my eyes to this world. It's a very fascinating area of law, historically rich and quite niche, actually. And when I was working there, a lot of questions kind of arose in my mind when I was working on these cases. And I go, what considerations does the government have? Like, what do they do when they're extraditing somebody to a country with known human rights violations? Does the current does the current system, what I would call in this presentation the Secretary of State's black box, is it satisfactory? Is it enough? Should we as a country put in more safeguards to protect human rights? And lastly, I thought of the role of the judiciary. What role, if any, should judges play in the extradition process? See if they could do more or less. And I found this case, and it pretty much addressed a lot of my questions. And so. And that's why I wrote about it. So just to jump right into it, my thesis is this, that unless Congress steps in and makes very clear amendments to the statutes as they stand, the Secretary of State will continue to enjoy Chevron deference in matters of foreign affairs, and the judiciary will continue to play a very minor role in the extradition process. This Ninth Circuit case, Trinidad, I predicted that their attempt to impose Administrative Procedure Act review on the Secretary of State will fail because they use shaky precedent, and it's highly divergent from the rule of non-inquiry, which I will go into in more detail later on. For proponents of expanded judicial review, in this paper I proposed a congressional amendment to the FAR Act. I recommended super clear language that could provide what other scholars in this area call a humanitarian exception. So this is the roadmap for the presentation today. First, I'll discuss Trinidad and some of its facts that really, quite captured me and, induced me to write about this. Second, I want to sort of walk you through the legal landscape of this in three parts. The biggest chunk, of course, is international extradition and the rule of non-inquiry. The second part, which is seemingly unrelated, is administrative law because it actually features very heavily in the Trinidad case. I'll talk about administrative law. I'll talk about the Administrative Procedure Act, as well as Chevron deference and the analysis used in interpreting statutory language. Then I will discuss basically the linchpin of Trinidad's argument, which is the Convention Against Torture and the FAR Act. Trinidad's unique claim, it wants to expand judicial review in a place where judicial review is very limited. And I predict that it would be unsuccessful and that the real solution lies in Congress. So it's a bit of a spoiler alert, but since I wrote this, when I wrote this paper, the case was currently on a Ninth Circuit rehearing en banc, and they had just come out with their oral arguments, which I was lucky enough to actually view on YouTube. Thank you, Internet. But since then, the court has come down with their decision, and it basically confirms my prediction that the narrow precedent that the Northern District of California court uses is they struck it down, and they also provide some really pretty interesting insight into where they believe their role should be in extradition, and I'll go into more of that later on at the very end of this presentation. So to talk about the case particular, this case stems from a habeas petition of a man sought by the Philippine government. He was a Philippine national living in California at the time, and the Philippine government wanted him extradited back to the Philippines to stand trial for kidnapping for ransom. Usually, extradition is reserved for the most egregious of crimes, murder, treason, that kind of thing, and kidnapping for ransom was not a very small deal. It was a very big deal. However, Trinidad issued two habeases, the second one which stuck for ripeness. His second habeas claimed that once he was returned to the Philippines, tortured very badly, and he provided a lot of evidence to that claim. He asserted that the U.S. has mandatory duties under the Convention Against Torture and asserted that the Secretary of State did not do enough and that due to the law, he needed to remain in the United States and that the Secretary should have not granted extradition in his case. Now, you may or may not know this, but the Philippines does not have a great track record for human rights. Amnesty International came out with a 2003 report saying that essentially torture persists in almost all levels of security and police forces for the government. And Trinidad, in his habeas claim, he brought what I found to be credible evidence through affidavits and court documents from the Philippines of what happened to 5 of his co-defendants that stayed in country. One of his co-defendants, Guerrilla, claimed that he stated the police came to his house in the middle of the night and abducted him. They blindfolded him, put him in isolation, and denied him food and water. After a few days, they kept coercing him to confess to this kidnapping, and he refused. After that, they tried to suffocate him with plastic bags. They poured soft drinks down his nose and forced him to eat rotten food. He still claimed his innocence, and the police just stepped up their terrible illegal actions. They shocked him with electrodes and wires, and they finally were successful in their coercion after threatening to kidnap and rape his sisters. Now, these claims by Trinidad's co-defendant were found credible by a Philippine court, and the judge there had, threw out his confession as inadmissible and dismissed all charges against him. Trinidad took all of these documents, all these affidavits in that court holding, and presented it to the Secretary of State at the time, who was Condoleezza Rice. And despite these facts, Condoleezza Rice still authorized the warrant for his arrest and extradition. When the California court, assessed his habeas claim, they asked for proof from the Secretary of what whether she considered his Convention Against Torture claim, his CAT claim. And in response, State did not say anything. They didn't send a memo. They just sent a generic document, defining what extradition was, the steps that the DOJ does, and didn't talk about his CAT claims at all. So, with this, I sort of just wanted to introduce the facts to kind of remind us of the human element that's central to all of these cases. I know, especially with circuit courts, it kind of gets stuck in the legal morass, but sometimes the facts are just so jarring, and it's really what prompted me to write this paper. So when I delved deeper into this case, trying to really parse what the California court was trying to do here in keeping Trinidad in the United States, I saw this very complex intersection of extradition and administrative law, and it was almost like peeling back layers of an onion. So I'm going to take a step backward, and I'm going to walk you guys through the background, kind of leading up to the claims of Trinidad, and before I address the meat of the argument and my proposals. So extradition, international extradition, is purely a matter of treaty. I know this the only picture I pulled up was from the Treaty of Ghent, so it may not apply, but that's okay. Extradition is the formal procedure of one state sending or transferring an accused or a fugitive to state to the second state, the requesting state. And this transfer can be done with or without the accused's consent. Most famously, we think of all the high-profile cases like Noriega and George Wright, who abducted a plane in the 70s and transferred it to Libya. He'd been in hiding for about 2 decades until he was found in Portugal. Also Roman Polanski. These are pretty big deals. But extradition, strangely enough, is its own legal animal. It's not a criminal case. It's not a civil case. It's not even an immigration case. Thus, the role of the judiciary is quite neutered, and you can't even, and the types of cases that come in here don't enjoy the federal rules, like protection under their federal rules of evidence. None of this stuff applies that you would think would apply in a typical case. Thus, without the federal rules, a lot of the evidence brought by the government against specific defendants, it could be full of hearsay, essentially. The best comparison, I think, of an extradition hearing is more to a probable cause hearing than anything else. The rationale behind that is that a full and fair trial will be held in the requesting country once that person is transferred. The U.S. enjoys about 3 levels of diplomatic relationships with different countries, as that map in the beginning showed. The top tier is the best tier. It's bilateral agreements that are renewed every year that provide for the smooth transfer of alleged criminals to partners like Canada, England, Mexico, and France. The second tier is more ad hoc, and it really depends on the diplomatic temperature between the U.S. and certain countries. So I'm thinking Afghanistan, China, even the Vatican. This kind of stuff gives the DOJ a bit of a headache, because without precedents and without longstanding relationships, the procedure and the transfer of evidence is haphazard. It's not uniform, and it takes a really long time to get these cases through the pipeline. And lastly, of course, there are countries where the U.S. does not have any diplomatic relationships. So I'm thinking, Cuba, Iran, and North Korea. And this is, if anybody gets in trouble there, it's very, very hard for the U.S. to deal with them and to either extradite you or vice versa. So the next two slides I'm going to show sort of to demonstrate how complicated the extradition process has become in the country nowadays. So this slide indicates what an incoming extradition request entails. And first, a foreign government, they want somebody who's in the United States. They send a formal request called a letters rogatory through their embassy in D.C. to the State Department. The State Department then gathers all this information and basically sends it to the Office of International Affairs in the DOJ. While there, the OIA will assess all parts of this request and see if it's in compliance with the treaty that we currently have with that country. And then the last step, which is I find the most unique step, is that the DOJ has to contact the USAO's office in the district where the fugitive is found and then do state-level litigation through a U.S. attorney at that level. So what you're dealing with is, I mean, people in the Department of Justice obviously have many years of experience with international law and treaties, but the glut of cases either go through the Southern District of New York or outliers like Kentucky or Oregon or Texas. And so at that level, you're dealing with lawyers who may not have taken international law at all, may not even have left the country, and also dealing with judges, district court judges, who similarly may not have the same exposure to international law that somebody at the DOJ has. And what's more interesting about this is that the USAO in court, they have to represent the interests of the requesting country and not the interests of the United States. It's almost as if the United States is acting as a conduit for example, if England is requesting somebody, they're representing England in a federal district court level. Yes, don't pay attention to all the details of this, but I just wanted to show sort of a simplified pathway of a typical extradition hearing. Treaty analysis is an executive function, undoubtedly, and with the separation of powers, judicial role is severely limited. Deference is often given to the position of the executive branch, and judges at the state level, they can't accept conflicting evidence in their extradition hearing, and they could only determine a very limited number of issues. So once you get past all those initial steps, you're in that center extradition hearing, it's pretty quick. I mean, the judge only sees if there's a valid treaty, if the criminal act of the accused is in the treaty, if there's dual criminality, which is, like homicide, if it's a crime in England, it's a crime in the US, that's dual criminality, whether the person is properly ID'd. I think this is probably the most challenged of the issues at extradition hearings, and whether there's probable cause. I mean, essentially just a smidgen of evidence that the accused committed the crime. Similarly, once that decision comes down, and most often, I mean, by far, the extradition magistrate approves of extradition. The Secretary of State makes a decision, and then the accused has standing to bring a habeas. Traditionally, and in modern practice, habeas is similarly limited. I mean, they basically look at those same issues that the judge looked at in the extradition hearing, and they also look to see if the extradition magistrate at the trial court level had jurisdiction. That's about it. All of this points to modern day practice of what they call the rule of non-inquiry. I mean, essentially under this rule, trial and habeas judges, they can't inquire about the treatment of the person to be extradited in the requesting country. This rule has its roots about 100 years ago, over 100 years ago, in Neely v. Henkel, I think it was 1901. And it's a case where the country, where the judge threw out a habeas claim by a fugitive in favor of Cuban sovereignty. They said, this isn't for us to decide. We're not giving him we're not going to give him a full trial here. Cuba will. And so that really set the stage for developing what the DOJ does now on the federal level and in different states. Currently, the precedent for this rule is all over the place, and every single circuit follows the rule of non-inquiry, including the Ninth Circuit. So that's what really intrigued me about this case, was how this court was trying to fight sort of the majority view on the use of this rule. So the next step in my analysis was looking at administrative law, which I wasn't, when I was reading about this case, I wasn't familiar with administrative law at all. I am now, but at the time, I was like, this is very intriguing. Administrative law was used in the court it was central to the argument because they dissected and reinterpreted statutory language that related to extradition. The Administrative Procedure Act was created in the 1940s to prevent agency abuse. The courts set up, or they favored judicial review of agency actions, and essentially would allow an aggrieved party to benefit from judicial review if it was wronged by a final agency action. The Heckler case allowed it if there was no adequate remedy, alternate remedy for the aggrieved party, if the statutes did not preclude judicial review, and also if the action itself wasn't committed to a specific agency by law. And the standard used there is arbitrary and capricious. Now, with Chevron is used, I know it was originally an environmental law case, but now it's been used widely and applied in many different areas of law to sort of parse ambiguous statute language and address whether deference should be given to the executive branch. There are two steps, famously. The first step is to look at the language itself and decide whether congressional intent was clear. If it's clear, deference will be given to Congress and the interpretation ends. If the statute is vague or is open to multiple interpretations, then you move on to Chevron step 2, which the court will determine whether the acting agency's interpretation of the statute is within permissible construction. If it's reasonable, then the agency gets deference, despite whether the court agrees with them or not. So this Chevron deference gets complicated when a congressional statute is limiting habeas review, and the St. Cyr case raises the bar to a super clear standard. So Congress requires they require Congress to have a super clear statement to repeal habeas relief, and I think the roots there are through the suspension clause of the Constitution, saying that obviously to preserve human rights. The statutes at issue in the case is the Convention Against Torture and the FAR Act, and there it was a global phenomenon. There was roots in international humanitarian law and international human rights law, but truly in the 1980s and 1984, the UN General Assembly adopted it as a treaty that prevents the transfer of people where it is more likely than not that they will be tortured. Now, the UN adopted it in 1984, and the U.S. signed and ratified it as a non-executing treaty in 1994, about a decade later. And a few years later, they turned it into law in the Foreign Affairs Reform and Restructuring Act of 1998. So this brings me back to the Trinidad case. Using administrative law as sort of their main weapon, the California court makes a claim to expand their role currently in the extradition process by reinterpreting the FAR Act. They do this by actually relying on one case, just one, that claims that they can do this, and it was a California case with very, very messy precedent. Now, they claim that the FAR Act was not clear on congressional intent regarding judicial review. And then taking the next step, the court finds that the agency interpretation or Secretary Rice's rejection of his CAT claims was arbitrary and capricious, given the fact that they had nothing to go on besides a generic memo regarding what extradition was. So in that Chevron step 2, which they did not want to give deference to Rice's decision to extradite him, and they essentially wanted to overturn her decision. They redefined everybody. So they said the Secretary of State, the State Department was an agency, and that the Secretary made a final agency decision, and that Trinidad himself was an aggrieved party without any adequate alternate resolution or remedy. So thus, using administrative law, they said that this man was entitled to APA review of the Secretary of State's decision. This decision was obviously made in a black box. So when faced with an empty memo, they found no choice but overturned Secretary Rice's decision to extradite, and they released him. So on and so forth. This was obviously appealed, and the Ninth Circuit rehearing en banc, which I read after I'd finished this paper, they did what I predicted. They said the decision per curiam overturned that one case that they used as precedent. They said, look, in the face of all the precedent in every single circuit, including the Ninth, we cannot find this like a valid use. They overturned that case, but they did something strange. I mean, instead of just ending it there and approving this extradition, this motion for extradition, they vacated and remanded the case back to the trial level so that the Secretary of State could augment the record. They didn't describe exactly what they wanted. And I interpreted that as sort of a modicum of proof that the Secretary had considered these torture claims. And that could be maybe a memo written by somebody else but signed by Secretary Rice. They didn't go into any details. What they said was that the CAT and the FAR Act basically imposed a mandatory duty on the Secretary of State to consider these claims. But then they wanted a least intrusive method for the judges to get involved and to basically confirm that the Secretary did indeed look at these claims. Now, this case, I mean, the decision that came down had 3 or 4 concurrences that were just widely divergent and all over the place in their opinion on where judges should be in this position. One judge lamented that his colleagues, by this per curiam decision, turned a rule of non-inquiry into a rule of some inquiry. And another judge who focused on the facts of the case where she disagreed with the holding whatsoever, but she agreed that the case needed to be remanded for more evidence. Now, this leads me to my proposal. In the holding that came down, there was a lot of language in all the judges saying, look, Congress's language is unclear, and if Congress gave us an invitation for judicial review, we will take it. And I think the repetitiveness of that assertion in the holding, confirms the fact that the solution is through Congress, which is what I felt to be the case. And, by providing an amendment to the FAR Act, to basically bolster our commitment to the Convention Against Torture, Congress can provide super clear intent to include safeguards and provide possibly alternate roles that can work with the Secretary of State instead of challenge the Secretary of State on a case-by-case basis. The extradition magistrate, with its limited role, perhaps it could be expanded to some in-camera role where the Secretary of State could write a memo describing some of the evidence, some of the maybe the assurances by the requesting country that this person will not be tortured, sign it, send it to the judge, and by doing an in-camera review, this will prevent the brief or the memo at hand to be released in public record. And then another suggestion I had was to emulate other European countries who they create internal committees that are independent of their equivalent of the Secretary of State that will give full assessment of the human rights violations and environment in the requesting country and give this recommendation to the judges or the Secretary of State. I mean, in that sense, it won't be the judge that is inquiring. It'll be the committee that's inquiring, and they'll be informing the judge. So I know that the case had come down the way I'd predicted, but I think it's pretty indicative of a larger movement. I mean, the Ninth Circuit is famous for sort of being renegade and trying to challenge precedent. But I think given the larger themes of Chevron and executive deference, especially in a time of, during the war on terror and our presence in Iraq and Afghanistan, this case and the opinions of the judges has more wider appeal to audience. Well, thank you so much for listening.
introduction to the talk. Turns out that we're both alums of the Foreign Service School at Georgetown, a couple of generations apart, but I think you need to know that. That's my criticism, if any, to them. And I'm going to move, I think, to a couple of key points that give the author a chance to comment on. She remarks on the Foreign Affairs and Restructuring and Reform Act of '98, the Real ID Act of 2005, which required the Secretary of State to prevent deportation if there's reason to believe the, dare I say, illegal immigrant. Prevent the deportation of illegal immigrants if they'll be tortured on their return. But the statute only applies to deportation hearings, not to extradition hearings. Is there any evidence that Congress considered extradition proceedings in drafting that requirement?
Sure. You know, in sort of researching the Real ID Act and also the FAR Act, I found some congressional reports, House committee reports, you know, basically doing what the judges are doing in every single case. They're creating a dividing line. They say, look, a final order of extradition is different from a final order of removal. You know, this is not an immigration case. An immigration case has extra steps, has extra protections, whereas an extradition hearing does not. And, you know, when I was rereading the FAR Act and preparing for this presentation, as well as the Real ID Act, they talk about criminal aliens. And when I parse that corresponding language, you know, the connecting statutes, by that they mean somebody who's already been convicted. You know, that was the key word that they kept using it over and over again. These aliens, the aliens in question were found guilty in a court of law. You know, they enjoyed all of their rights through the criminal process. The Fourth, Fifth, and Sixth Amendments. You know, they had right to counsel. They could bring evidence. They could bring witnesses in their defense. And the FAR Act said, look, you know, we won't allow judicial review there because they've already been convicted. You know, they've gone through all the steps, and there were many places where judges could have intervened. And suspect aliens that are not convicted, I think we should really consider them in a different context. You know, they haven't been put through the criminal process, and they haven't been able to bring contrary evidence on their behalf. And so, you know, looking back at some of the records in Congress, it's not that they considered extradition, it's just that they parsed it and they only considered immigration.
Okay, and I suppose on the first step that Congress is saying we can't allow collateral attack on a conviction that was derived from in another foreign jurisdiction, no matter how many violations of due process that person may have been subjected to. The fact remains he was convicted, and we're going to send it back. Traditional jurisprudence, as I understand it, not only permits us, requires us to respond favorably to a request for a return if those items are proven, but that jurisprudence even obliges us to send back one of our own citizens.
Right, that's right.
Which is peculiar. Not all countries provide for extradition of their own citizens to a foreign country for trial. Now, your proposal that Congress change the law to provide for some sort of human rights evaluation before the extradition process takes place, most of your focus was on the torture convention. Mm. Would you expect the same sort of filtering process to take place on other aspects of civil rights? If, for example, the right to counsel couldn't be guaranteed, or your filtering process wouldn't just apply to torture cases, would it?
Right. I think with that question, there are many ways to approach it because it's really a matter of congressional will. The reason I focused on the Convention Against Torture and why I think at least the immediate application of a congressional amendment might just be on the convention itself and the FAR Act is because it's the most solid and the most recent manifestation of the U.S.'s will to abide by human rights law. You know, if that is the gateway to more due process rights down the line, so be it. But I think initially it might just be the torture claims rather than right to counsel. I mean, I'm not saying that it would preclude it. In fact, I welcome it if that's the case. But again, this is a balancing act. The U.S. doesn't want something that's a full and fair trial just yet. You know, that's not what we're guaranteeing here. We're guaranteeing at least some consideration of torture claims before we send them to the other country for a full and fair trial.
All right. And I suppose that traditionally the reason that we haven't done this is because we think it will affect our foreign affairs relationships with the requesting sovereign. Final question, I think. You mentioned kind of the human dimension of this whole process. How do you think, under your filtering system, this panel would handle a request from a jurisdiction which says, we're giving you conclusive proof in our judgment that the person we want extradited has a habit of capturing, torturing, murdering, and then eating small children? It's the ultimate hyperbole. Right. and here's our evidence. I must admit that this took place in the Philippines with unhappy human rights records. Now, do you expect this committee that you're proposing to engage in some sort of balancing process of how severe the crime is and how immediate the threat of torture is? How would the committee arrive at this kind of a judgment?
Right. I think with a crime such as that, as egregious as that, I don't think that such a committee should be balancing the weight or the nature of the crime versus what we're promising as a right under our own treaties and conventions. I mean, I think it may be hard and it may be very difficult to process somebody who's an alleged torturer to prevent him from being tortured. But in a sense, that this is why we have human rights agreements. This is our collective movement towards a better world. And I think everybody, including alleged torturers, deserve a certain standard of humanity.
I'm going to say one last thing and then turn it over. I guess, can I recognize speakers? Okay. My final statement was that obviously we've gone over this material in advance. That last question we had not gone over. And she was great.
President, thank you for an extremely interesting paper. I have to say, from a minister of law point of view, I find this all very strange. I mean, I would have thought the question of whether judicial review is included in habeas cases has a very extensive constitutional history before the Civil War, U.S. v. Milligan, U.S. v. Klein, the whole range of Guantanamo cases, Hamden and Budimir, and St. Cyr, as you point out also, the court, it says, because of the constitutional status of habeas and the suspension clause, there is a core constitutional concept of habeas that can only be suspended by Congress, and we need to be clear about it. I don't understand at all, really, how Chevron fits in. I mean, maybe they can use the terminology, but it is true that Chevron says that in interpreting the agency regulation, you applying a statute, you look to see if that statute intended the agency to have a range of options in its interpretation, and then secondly, if that range was reasonable. But it was only applied later to adjudication, and that's already stretching it. And it just seems to me that the whole term is really not compatible with foreign affairs statutes, where there's a traditional pre- and post-Chevron notion that courts give deference to the executive, but they don't totally get rid of the executive view, whatever the international law issue is, active state or whatever. The other thing is, I don't really understand, is the use of the, it's not you, I suppose it's the Ninth Circuit, the use of the APA. I suppose you would structure this as an informal agency action by the secretary, and if it's an informal agency action, the only thing that has to be is not arbitrary and capricious, which is why they say, give me any evidence, so that I can say it's not arbitrary and capricious. But again, there's a whole history of duty to give reasons or duty to actually consider. And it seems that from your report of the Ninth Circuit was all ignored. Furthermore, at least regulations under the APA are exempt. Foreign affairs regulations are exempt from most aspects of the Administrative Procedure Act. So if you're going to create a committee and all these kind of subsidiary institutional things under a statute, that requires some kind of regulation, and that would be exempt from the
Right, and that, thank you. All that insight was very, very helpful, and it will, help me when I tailor my paper later on for submission. And I think that, truly, that's the reason why I thought that their claim was going to fail. The APA was used only once before and completely shut down in the Fourth Circuit to attempt to override the Secretary of State's decision. And the APA, as you said, with the foreign affairs exemption, I mean, this wasn't going to work, but they tried it, I guess was why I wanted to highlight this case. They were going to try it either way they can, and if they weren't going to be successful, then their holding was going to be kind of a rallying cry to Congress, which is what I thought when the holding came down. It's like, I guess we were wrong, but Congress step in, please. That's what I read in this case. So with Chevron itself, I mean, I worked that into the analysis because, I was listening to oral arguments, and when this issue was brought back up to the court, the government was taking a very strong line. They said the judges shouldn't have habeas jurisdiction at all. They said that the Real ID Act was jurisdiction stripping, as well as the FAR Act, and I found that very, very, very indicative of them wanting Chevron deference on all things extradition, moving forward, which actually in their holding the court did not agree with. The court said, look, all of these statutes say that we still play a role. What kind of role that is, they're not quite sure yet, and will still be hammered out in maybe future cases to come.
That's another point. Then you have to pause when I have people coming. But there is a controversy over whether a government position in a brief or an oral argument should get Chevron deference in any event, because the whole notion behind Chevron deference, and the courts have pretty much accepted this view, is that it reflects a considered view by the agency. And normally that's why they saw it in regulation as being notice and comment rulemaking, because that would be a considered view. And of course, an advocacy brief or oral argument is, except for Justice Scalia's belief, not considered a considered view. But anyhow, I want to thank you very much. It's very interesting. I'm going to read those cases, and I look forward to reading your note. Excuse me. Thank you.
Hi, I love the presentation. I should confess, I used to work on extradition at the State Department for 2 years with OIA. So I lived to read this, and I was one of the evil State Department people who rushed to get people out of the country as fast as we could. And he was deposed once in a case involving human rights, allegations of human rights abuse by a guy who would be sent back to Hong Kong. And so I thought a lot about this question. I was really intrigued by your presentation. And I wanted to toss at you some of the inevitable arguments, counter-arguments you'll get from the State Department and from the Justice Department, from your buddies at OIA, opposing your proposal, and see what you think. The principal argument, I think, would be is we have a treaty obligation to extradite. And when we enter into a bilateral extradition treaty, we make a policy choice whether or not we are going to accept that system's criminal justice regime is acceptable to us. For that reason, that's why your diagram of extradition treaties around the world omits China and Russia and almost all of Eastern Europe and much of Africa and much of the Middle East, Saudi Arabia with no extradition treaty. When we finally entered into an extradition treaty with South Korea, which is on your list, it was after a long series of hearings and after negotiations with the Koreans in which we put in the safeguards in the treaty itself. And indeed, extradition treaties themselves often have human rights safeguards. For example, you can't extradite for a political offense to any country, to Britain, to France. If they request extradition for a political offense, we can't give extradition. And there are other, you can't give extradition for someone who's already been punished. There's a double jeopardy protection. So there are various procedural safety and human rights safeguards already in extradition treaties. So my question for you, and I anticipate the response from OIA and State would be, why isn't the answer to rewrite or to address your concerns through the extradition treaty itself rather than through U.S. law? By doing it through U.S. domestic law, you put us in jeopardy of violating our treaty obligations. Why not change the treaty obligation? Why not say, if we're going to have a treaty with South Korea, we will not extradite if there are credible allegations that the extraditee will be tortured?
Right, that's a very excellent question. And as you stated, I shared my paper with my colleagues and my boss at OIA, and obviously they said they don't agree with me. But I just had to put it out there anyway. And truly, I mean, you're right. We can put in these safeguards in every single treaty that we establish, but then that would leave it to really like diplomatic will again. I mean, it would take a really long time to negotiate these kinds of things. I mean, I know that there have been more robust examples of that. I know there was an extradition supplemental treaty with England that prevented extradition based on like race and religion, but that just came out of the Good Friday Agreement, and the conflict between Ireland and the UK. So if it takes an event, really a conflict and a war like that to put in these additional safeguards, how much harder would it be to really negotiate these treaties with countries like, hopefully China in the future? It's going to be very difficult, if not impossible, every single time to get it just right and to get it uniform. And just to let you know, the Philippines also signed the Convention Against Torture. So I don't know what kind of duty the U.S. has as a co-signatory to maybe help other co-signatories, keep up with their promises and their own treaty obligations. So that would be my response to that.
I guess a follow-up question I have for you might be, I expected you would say it's going to be too hard to renegotiate 120 extradition treaties, whatever it is. And that's a reasonable response. Is perhaps a follow-up answer, maybe we should have one extradition treaty, a multilateral extradition approach like the Europeans do? You mentioned the Europeans, and I was interested to hear more about that. Should we have one extradition treaty which includes these safeguards, includes the committee? Should we follow Europe's lead as well?
Right.
Are you proposing, you're not proposing that?
Well, just knowing how volatile all these different relationships with different countries are, I'm not sure if a universal extradition treaty with every single country in the world is going to really pan out. I mean, the European multilateral treaties are among the Western states. They're not even with the Eastern European states. So if they can even get it together, how are we going to get it together with our with countries with completely divergent political systems?
Yeah. Great stuff. I love it. I love the talk.
Thank you.
So I think a follow-up to Professor Lacson's question is, what do other countries do? Do other countries consider human rights violations when they're making this decision about whether to extradite somebody?
Right. I guess in my research for this paper, I uncovered some things that other countries do, and it is the human rights agenda is very strong in Western Europe, and again with their multilateral treaty. I might be messing this up. Maybe the Strasbourg Agreement. They have these committees put in place to make recommendations, and these committees, I think, actually do have the power to prevent an extradition based on human rights law. And
I think you're thinking of the European Convention on Human Rights.
Yes.
The most famous example was when we sought the extradition from England of a guy who killed somebody at UVA, University of Virginia, and the Brits wanted to extradite, and the defendant brought suit before the European Convention on Human Rights, and the European court, even once in the European court, enjoined his extradition here on the grounds that he would face the death row syndrome and he would be psychologically harmed by facing the possibility of the death penalty in the United States. And so we eventually did get his extradition, but only after negotiation with the Brits. So they have the system, they have a separate court. It's not really a committee, it's a court that can intervene in extradition cases and stuff. That's an interesting model, and that's why I was curious whether you wanted to go that direction. It's a pretty drastic change in our...
From the way we currently do things.
Excellent presentation.
Thank you.
Many thanks for it. What would the adoption of your proposal do generally with respect to this country's ability to gain extradition with respect to people who allegedly have committed crimes in this country and gone abroad?
I guess the proposal here, it might, I guess on a narrower scope, it affects people who are being extradited from the U.S., but you're right, I think we should really be cognizant of our relationships, our diplomatic relationships with other countries and what this might do. I mean, I think it might even, I think it might make our relationships better, knowing that, you know, in sort of like a tit for tat, like if we treat their extraditees with full and fair trial, like maybe they'll do the same. You know, granted, this all depends on the type of treaty and agreement we have in place with them, but I think that these amendments might improve the relationship, actually.
Well, I'm sure there are many other questions, but I'll let you ask them to Elyssa afterwards. And let me thank her for, I think, what everyone would agree was a stellar presentation. This is on behalf of the faculty to Elyssa Lacson for the second presentation of the Student Scholar Series this year. Thank you very much. Thank you all for coming. Come back April 17th for our third presentation, the Hanging Cocoa. Thank you.